meantime, if you don't mind, I will go over the bill a bit. Today I present to you SB 503. You recall this bill would allow judges participating in the Judges Retirement System 2 the option to make a one-time written election for their retirement pay for any number of whole years of service as a subordinate judicial officer. Current law requires the former subordinate judicial officer to purchase all of the time he or she served as a subordinate judicial officer, which can be more time than he or she needs to attain full retirement under JRS 2, and can be prohibitively expensive. SB 503 would allow judges to purchase their desired SJO credit time without being forced to buy all of it. As you know, it's back from the Assembly in this committee because of both some technical amendments and a substantive amendment that we're certainly going to talk to, as you know. I would like to introduce Mike Belote, representing the California Judges Association, who should be here momentarily. They did want to testify on the amendments and discuss the amendments. I know that my staff is diligently attempting to find them now. Why don't you... They are trying to get... Supposedly he's on his way. And again, I apologize for the delay.
Well, they probably thought we were going to meet till 3, and they...
Yes, I believe that there was a question of time. I believe the floor exercises, if we can call them those.
So why don't you tell me how this has changed dramatically?
Well, I wouldn't say dramatically.
Well,
I would say change substantively.
Okay.
The way that it's changed substantively, obviously, is the issue of the 180 days being able to return to work as a retired judge. As you know, the Assembly and the Senate have passed other bills with respect to that do not allow former employees of the state to come back within that 6-month period. The amendment would allow judges to do that. That's the substantive change as opposed to the technical changes. There are reasons for that. I believe that the sponsors, I advise them to talk about that, and I know that they're on their way, and so they are here. And they can address that issue. Again, as you know, the bill dealt with the election, but now this was the one substantive amendment that we'd like to address. If you could hold on just one second.
If you want me to pull it out, that's what I do. Is that what we needed? I guess.
Yeah. Do we? Okay.
Madam Chair and members, Mike Belote for the California Judges Association, co-sponsor of the measure. The initial portion of the bill was very, very simple, dealt with the ability of a commissioner who becomes a judge to buy a portion of their prior commissioner time in the judge's retirement system. Present law allows the commissioner to buy that time, but requires you to buy all of it or none of it. There was no reason why that limitation should apply. So our bill started out simply saying you could buy a portion of your time because you don't need to buy all of it often. It wasn't airtime. This is actual time spent as a commissioner. Subsequent to that, 2 issues arose in Sumitian and Furutani bills dealing with double dipping. The concern of those bills, as I think you all know, is an employee who retires, puts down their pencil today, and starts to work tomorrow in the same job, and they collect their retirement and a per diem rate for their new job, or the same job. There were 2 what we thought were unintended consequences for judges in that. The first relates to situations where a court commissioner position under present law is converted to a judgeship. And the governor is given the authority to convert a certain amount of positions each year from the commissioner positions, and they've been doing that now for several years.
Is that to cover the lack of judges in many areas?
Doesn't add, But the concern of the prior Chief Justice, George, was that we want judges doing judges' work. Judges are elected. Judges are accountable to the people. When in doubt, we should have a judge rather than a commissioner. But the same work is being done, whether it's by a commissioner or a judge. It was really a good government thing. We should have people who face the electorate when we can. So, the conversion can't occur until the commissioner retires. There's no vacancy. There's nothing to convert until the commissioner retires. But you can't fill the position until the governor makes an appointment. So the idea was the commissioner should be able to continue working, retire today, and continue working tomorrow until the new judge shows up, just so the work gets done. It's not going to be the same commissioner. We're not converting Commissioner Ackler to Judge Ackler. Commissioner Ackler is retiring, and the governor is appointing Lawyer Vargas to the judgeship. It's two different people.
I accept.
We're just asking that the commissioner be able to keep working until the judge shows up without having to have a 180-day window there. Okay, that was the first unintended consequence. The second one was this. You have a deputy attorney general who retires, wants to take a judgeship. He or she has applied to be appointed as a judge. The Summidian bill would appear to require the deputy attorney general to actually retire, if they want to retire, to sit out for 180 days before they can take the judgeship. And that didn't make sense to us. It seemed like it's a totally different position. It's two different branches of government. We thought that the deputy AG ought to be able to retire today and take a judgeship in another branch of government if appointed by the governor without the 180-day problem imposed by the Summidian bill. We thought those were technical amendments not within the what was contemplated by Senator Summidian and Assemblymember Furutani. And so we put those in the bill as exemptions, if you will, from those bills. Now I understand there are some concerns, and we certainly want to work with you and your staff in the Senate to make sure that we resolve them. If the ultimate decision is to take those two things out and to proceed with what we thought was a completely non-controversial first portion of the bill, then we will do that. That is, frankly, up to the chair and the collective wisdom of the author and the Senate. If that is what you would prefer, we will do that. That means sending the bill back to the Assembly, rescinding the floor vote, amending it, and repassing it on just the non-controversial first portion of the bill.
But what will you do about the second problem? Because it'll still be a problem.
That remains a problem. And,
if I can bump in here, we attempted, obviously, to address it in this bill. We thought it was something that wasn't contemplated in the Summidian bill, but if it's something that would prevent us from fixing the first part, we would take it out again, as the sponsors have stated.
We thought it was non-controversial. If it in fact ends up the collective wisdom of the majority party, the minority party, the author, the chair, the staff, we'll take it out and proceed with just the first portion of the bill.
Okay. Are there any questions from the members? Mr. Gaines?
What the heck was he talking about?
Yeah, please, if you could.
Confusing than we thought.
Yeah, if you could provide a little more clarification in terms of the service time purchase. Now, you're talking about a commissioner that could be
Present
into a
law
judgeship.
Allows a commissioner, and this happens periodically, where a commissioner has done a great job and the governor decides to appoint them to a open judgeship, typically in the same county. The present law allows them to purchase their commissioner time in the judge's retirement system, but it said you had to buy all of it. Well, you might have had 15 years, and you can't afford to buy 15 years. You don't need to buy 15 years. You might only need to buy 3. So what our bill would allow is you would have to cash out from the first system. So you can't be a member of both. So you take your money out of the first system and you buy that portion of commissioner time in the judge's retirement system that you wish to buy at the actuarial cost. This isn't supposed to be a gift at all. It's not supposed to cost the state or the systems any money. It is at the amount PERS says is actuarially required to buy that time. So all it changed was you could buy a portion instead of all, and that was the sum total of the bill.
And the portion would be purchased upon retirement from your
Present
judgeship?
law allows, funny you mention that, present law allows you to do it at any time. There was a concern that, how do I say this simply, if you purchase it too long in advance of your retirement, you know, the stock market could have crashed in that period, or there could be something that makes it not be the right actuarial amount. So there were various talk about truing up the amount, and we said, no, simpler, just limit the purchase to when you retire so that you get the valuation and you make the decision then, do I buy it or do I not? So that's why we did that change.
And how's the noticing work for retirement? Do you give retirement, is there X number of months, or is it, I mean, could you announce your retirement a year in advance, or is there any criteria in terms of when that occurs?
Don't know. I don't think there's anything preventing a commissioner from retiring very quickly. I don't think there's no required notice period.
Okay, how about a judgeship though? Because I'm focusing more on the judgeship. If let's say you got appointed a judgeship and you're trying to purchase this time, when does it?
You couldn't purchase that time until you're retiring as a judge. And I apologize. This is Tracy Kenny with the Judicial Council. We share in all the comments of the Judges Association. I just want to point out the reason that service credit purchases are relevant for these subordinate judicial officers, in particular in the judicial judges retirement system, is that you need to have 20 years of service before you're eligible for a defined benefit pension. And so they need to accrue a much larger amount of service than the typical public employee. And so being able to cash out of their other system and buy at a higher cost some of the years might allow them to retire prior to age 70 in JRS 2 rather than having to work all the way till 70 to be eligible to retire. So they're in a pretty unique situation relative to other public employees who might purchase service credit.
So they would typically, I think, contact JRS and say, I'd like to purchase my prior commissioner time. Give me a value. And it's not inexpensive at all. Those purchases are expensive and hard for people to do. It's only been done once, as far as I'm told. It's only been done once. So,
you know over what time frame that is? It's only been done once over.
The system was created in 1994. So.
Okay. Very well. Thank you.
Any other questions? Well, since the author is graciously said that he would take out the Second Amendment and just go with what you wanted to do now, I think that's probably what we should do to get this out of this committee, and that way we won't have conceivably a fight on the floor to get your bill out.
Okay, and so just to clarify then, I believe the bill then would be amended simply to take it back to how it was prior to those substantive and technical amendments. Mm-hmm. Is that correct?
Is that your understanding too? Yes.
Again, Madam Chair, with all due respect, that would not be our first choice, but if that is the will of the committee, then that's what it is.
Yeah, I think there has been expressed some concern about the Second Amendment being put in, and rather than have your bill fail because your goal is to get that first part out, I think that's probably what we should do. I know that isn't what you really wanted, but concern has been expressed to me, and I really want to see what your first goal was to get out, and I think maybe that's what we should do now. And then next year you can, or at the beginning of the year, you can see if you can get that other part into another bill. Okay? All right, so are you in agreement?
Make those amendments. I would ask then for those amendments, how would we accomplish that technically? Maybe we could ask staff, and staff could help on that.
My understanding is that you would agree today in the committee to send, the bill would go to the Senate floor, and then upon the Senate floor you would request that it be returned to the Assembly to be amended to remove I think specifically the provisions relative to the 180 days.
And I would make that into the form of an amendment, if that's what it's called. I don't suspect that's what it's called, but that's what I would ask for.
Okay. So then we would move the bill then to accept the first amendment as it came back from the Assembly, and then to remove the second amendment out.
Excuse me, Senator. I believe the motion would be
To make the motion then.
to make the motion to send the bill to the Senate floor.
We're going to move it to send to the Senate floor. And in that case, then at that time, you will ask to be sent back to the Assembly to remove the second amendment.
Thank you, Madam Chair. That's what I would ask. I would ask respectfully to send the bill back to the Senate floor. And there I will ask that the bill be sent back to the Assembly for amendment in the Assembly, then for the bill, hopefully, to come back.
Yes.
Yep.
Yes. Okay. Let's try to figure it out.
Sure.
We only have two motions that realize the whole bill needs to send it to the Senate floor. But Senator Vargas has promised if we send it to the Senate floor that he will then ask that the bill be returned to the Senate to be amended to remove the provisions relative to the 180 days. Okay. Sure.
Okay. So with that, that everybody understood, I will call for the vote.
Negrete McLeod?
Aye.
Negrete McLeod, aye. Walters? Aye. Walters, aye. Gaines?
Aye.
Gaines, aye. Padilla?
Aye.
Padilla, aye. Vargas?
Aye.
Vargas, aye.
Thank you so much for being so gracious in accepting this. and
Thank
the
you very
sponsors.
much. Appreciate it. Thank you.
Thank you.